Good evening to the students of the International Human Rights Law. Welcome to my class and read what I posted on the screen so that I could know that you are with me and I am with you and both are traveling the same boat to reach the destination. Read. I said unmute and read what I posted on the screen.
The defects in international human rights.
Yes.
The United Nations project, as envisaged in the Charter, was never meant to be legally enforceable by international means. The terminology was remarkably weak from the start, with the core expression of protection and the promotion of human rights as a testament to the soft law character, whereas the rights signify abstract commitment to protection of an interest by law. Human rights refer to interests directly connected to human dignity vis-a-vis fundamental freedoms and the basic entitlements. To protect human rights, then, means protecting the protection of these interests by law. Such a discourse obviously weakens the missions. Professor Dr. Mohammed Saheb Hussain.
Yes. Thank you very much. Defects in the international human rights law. Because the UN project as envisaged the charter was never meant to be legally enforceable by the international means. Enforcement machinery is not in proper way in the international law. That's why we can say international law is a weak law or international law is a soft law. The terminology was remarkably weak from the start, with the core expression of the, I quote, protection and promotion of the human rights, I unquote, as a testimony to its, I quote, soft law, I unquote. It is their character. Whereas rights signify abstract commitment to protection of interest by law, they say protection and promotion, and which were not concrete, it will be abstract. The interest by law. Human rights refer to the interests directly connected to the human dignity. But the human rights are there, which is directly connected to the human dignity, namely equal in English language. It is a Latin terminology, vis. It is a shortening form. Videlicet is the full form of it. Fundamental freedoms and basic entitlements are there. 2. I quote, protect human rights, I unquote, then means of protecting the protection of these interests by law. Any protection through the law, but it should be executed. That is more important. And that is lacking from the beginning in the international charters or international law. But certain measures should be taken by the UN, like the sanctions, economic sanctions, diplomatic relations should be curtailed, no transportation, boycott, and if the necessity would be there, UN peacekeeping force would be sent to curb the unruly mob and promotion and production of the human rights, if it is evidently done in the particular country where the state of that country is failed to make it out. Such discourse obviously weakens the mission. So when the merely right is there, without its implementation, the right is useless, or we can say fructuous in other way. And sir, if you happen to see the syllabus, problems of applicability of international law, and international politics are there. Sir, when you say the international politics are there, but you are every time teaching international relations. So whether there is any connection between the international politics and the international relations is there or not, I will make it prove that it is there. Read what I posted on the screen. Read what I posted on the screen. Malibwa.
Uh, international politics is nothing but international. Sorry,
Very
is not showing full.
This one. Highlighted one.
Okay. Okay. Is international politics the same as international relations? International relations is a broad field that helps create bonds between nations through economics, social, and a political relationship. International politics is a subset of the study of international relations, and as such, it requires critical thinking, skills, and proficiency in cross-cultural communication.
Now you tell me, international politics is a genus or it is a species?
Pardon, sorry?
International politics is a genus or species? I repeat the question. International politics is a genus or a species? Did you understand my question?
No, I haven't got your question yet.
Then
Sorry.
why you are not giving the answer? Sir, I did not get your question. But you are not speaking. 2 times or 3 times I repeated. Genus means the bigger one. The premise size is very big. Species means it is one of the in the genus. Means part of it. International politics is a subset of the study of international relations, which is Makubwa, which is Madogo here, which is a bigger one, which is a lesser bigger one.
International relations, I think, is a bigger one, and international politics is the smaller one.
So which is
Comes
a
from the
genus, which
international
is a
relations.
species?
Yeah.
Which is a genus and which is a species? I told you genus Makubwa.
International relations is the genus, and the international politics is the species.
Now did you get me? What is species and what is genus? Say yes.
Yes.
So
Yes.
international politics is a small set of it, but the international relations is were bigger and wide range. So that is the question. When you say international politics means a smaller one, we are reading the bigger one, international relations, in our study. So that is why I say problems of applicability of international law and international politics and their impact on human rights. It is nothing but international relations impact on the human rights. And the human rights will human rights, because of the human rights, international politics will be survived because it will protect it whenever that it is violated over there. Norms are violated over there. So 2.6 is the last topic that we are dealing. After sometimes only the revision would come. Okay. So now, in your last class, we are here. Where we are, I will show you. This is the latest one, but the last class, yes, we will come to the point. See, I already made, but I don't know where it is disappeared. Yeah. No, it is not. And this is also not. So we are dealing in the last class. I will come to the point. No, it is there. Okay, doesn't matter. I can trace it out. Because we'll continue from there. This is not. I already put it on the heading. Yes, it is there on the heading. The function of the international law, namely as a system, international law is an autonomous legal system, independent from the international politics, but its main function is to serve the needs of the international community, including the authentic state system. And in particular, Koskeneme concludes that the function of the international law is to emphasize its task as a relatively autonomous formal technique, as well as an instrument for increasing the special claims, agendas in relation to political struggle. International law and its institutions have the purpose and function of maintaining the realization of the idea of the balance of interest, the idea of harmony of interest. We cannot make a separate where the international relations are there. Definitely international politics is a subset of it. We never go into the politics of a particular country, but we will think about the having a relations with another country in the trade and commerce or in the industry or any other aspect of it, including the agriculture. We would like to have the relationship with the other country. Suppose a country is very good in the agriculture production, we will try to learn, the other country will try to learn how the production will be increased and what the techniques are followed in the agriculture. Unless until there would not be a relation with another country, and this cannot be possible. Of course, we don't play the politics over there, and we will see the development and peace and harmony and the good life would be survived over there, and a dignity life that is more important. So to achieve all goals in each country, to achieve all the good, socially, economically, politically, environmentally, legally, international law has a role in international relations. So international law definitely plays a role in the international relations, including, when you say international relations, it's a genus and the international politics is the specie. So international genus we are making, including first, international law is intended as an effort to maintain the peace and ignore all forms of the regulations that don't like various regulations related to the high policy, namely those related to the issue of the peace or war. So the regulations are there. For what purpose these are all regulations? For the maintenance of the peace and development and health of any country, and ignores what it can be, ignores all forms of regulation that don't like various regulations related to the high policy. The high policy or the political policy or the policy of a nation, we will see it how it can be made, but we don't interfere in the politics of a country, namely those related to the issue of the peace and war. So we will concentrate on only in the peace, not in the war. Problems that occur between one country and another, a country with and many countries will cause conflict, and a conflict both in relation to the rights of the country or many countries, or with the customs of a head of the state, diplomats or ambassadors. There would be a different legal system would be there, a different culture would be there, a different brought-up would be there from one country to another country. So another country subject entered in the another country, a host country, definitely there would be a imbalances are there, and the probability is more there, violations are there, abuse are there. And hence, because of the various customs brought up and the way of living and the dignity of living of a particular head, the customs of the head of the state, or diplomats, or the ambassadors. All of these subjects have their respective rights and obligations. Rights are there, obligations are there, which in practice must follow international games and follow the rules that have been agreed upon collectively or internationally. How we agreed collectively and internationally? Because we are the party to the charter, we are party to the treaty, we are party to the multinational, multilateral, or the bilateral. At that instance, we have to collectively follow those norms and regulation of the charter. The second point is international law functions for foreign offices and the practice of the international lawyers who daily apply and consider settlement with the rule of international law relating to the various related matters and cases. And there are the lawyers are there, they deal the international cases or one country to the another country cases, and they will see that which is nothing but civil matters are concerned, and that is said to be the private international law for settlement of the dispute would be there either in the breach of contract or in the matrimonial issue or the settlement of the transfer of the mobile or immobile property or the succession is concerned. At that instance, we follow the law of the land and the form of the procedure of the law of the forum and substance, which is the lex causae, where it is very much connected with, most connected with the relations with a particular state is there, and that state law would be followed, and the disputes can be resolved. Cases, for example, regarding the claims for the compensation of foreigners who have been involved in an accident. Suppose a foreigner is involved in an accident where he got injured or he made an accident. And except in certain cases, exempt privileges are there, but in other cases, the compensation should be paid. And incidents of deportation of the foreigners, extraditions, national or nationality. So, if any person has committed a murder and flew to the other country, taking the asylum, if there is the extradition treaty is there, that country will hand over the culprit to the nation where the crime is committed. So deportation would be there. He will be sent back to their own country. He will be deported to the own country of foreigners, and extradition treaty would be there, one country to another country. At that time, the culprit will be returned back to the nation where the offense is committed. National or international nationality, whatever the national nationality would be there, or acts and the right of extraterritorially of a country, and they will go beyond the extraterritorial in a country because we will accept the judgment of the other country. At that instance, we say that extraterritoriality in a country, an interpretation of the rules of the complex treaty. And at the time, the treaty complexes are there, rules are there which are in complex in nature, and that will be interpreted by an international lawyer and convince the judge of a particular court. If it is in Africa, then Arusha court, human rights. If it is in America, then American court or European Union court in the Europe. These are the three regionals and institutions are there, tribunals are there. If there any violations would be there in the three places, it will be filed. I mean the human rights violations. For the other country, state to state, international court of justice there, or individual with the state, or state with the individual or the body, then the international criminal court is there if the criminal offenses are concerned. The third point is the international law also aims to assess various violations of the international laws, and as a result of war or conflict or because of the military aggression or the inability of a country to prevent the epidemic problems such a matter of the disarmament, international terrorism, and violation in the practice of the conventional military conflicts and non-international military conflicts. So the state should have to try to curb if any aggressions would be there, the violations would be there, and disarmament movement is started over there, and everybody try to kill the people like killing the birds. At that instance, there is a great endangered human rights violations are there. Seeing that the function of the international law is related to the policy theory, a policy and interest, there are two important aspects in seeing the aims and objective of using the term policy or international law. So if the policy of a country is also taken into consideration and what policy they would be there and how it can be curbed if there are any violations. Suppose if the state will not control the violations of the human rights, at that instance they can request the UN to interfere in the matter and see that to see a peacekeeping force will be sent over there to curb such human rights violations. So the fourth one is international law is related to the term policy as an objective which must be seen in the law of itself. Each of these policies is generally aimed at peace, at security, cooperation, peace, security, and cooperation. These are the three main objects of it to have a healthy life on the earth planet. Or at more specific matters are there. And first, a peace will come when there is no disturbance are there, no criminal crime is there. And security also comes where the violations are not there, where somebody's rights are not violated, then he will be secured. And the cooperation, each state has to make a cooperation having a relation with another state in all matters. In all matters, then only the state growth would be there and the state name would be there on the map of the world. So that was the thing. Then the fifth is the aim and objectives of international law can be seen from the policy, which emphasize the importance of the international community. So our foreign policy should be in such a way where it is the invitation to the other country to invest it. But we should not be like a closed one and living a life in the well like a chura, a frog. The existence of the policy as a special law in the international community, especially in a special situation, require the testing. And if you isolated yourself, not having a relations with the other state in the world, then your growth is zero. Are you following me? Are you following me?
Yes.
So international law plays very, very role to make it out, but still there would be certain lacunas. I told you, mechanism, that is executive machinery mechanism, that is not proper way, because there is, for a state execution is there because police is there, state police is there, state defense is there. For the international law there is no state police is there, or except the UN peacekeeping force, and that to be, it is sent by the each and every country, and who are the members of the state, they will send the force from their country, from the peacekeeping forces. Even Tanzania, Jeshi is a soldier. Yes. Defense people, soldiers, even Tanzania also will send it in the peacekeeping in the UN. Did you have an idea? Did you have an idea?
Yes, bro.
See, I told you once, I worked in the University of Asmara, Eritrea. At the time, there is a war between the Eritrea and Ethiopia. And I saw the UN send the peacekeeping force over there to curb the bombing and killing of the people. In the UN force, peacekeeping forces, I saw the many countries' soldiers are there, including India. I found the Indian people are there in the peacekeeping, and when I made the Hajj, they also took the permission from them and they performed the Hajj. the Muslims. And I found different countries, people will be there in the UN peace. For the tenure, they will go for 1 year, 2 year, like that. They will give the option and they will be selected. And the cream only will go over there for the peacekeeping. From each country, they will send. And that is the point of this thing. Policies are very important. Community, you cannot have a good foreign policy should be there. At that instance only, the state will growth and international peace as well as the security and the cooperation would be come over there when there are the international law is strong and the international human rights will be protected simultaneously. So let us see the conclusion, what the conclusion they have given at the last. International law can be formulated. International law can be formulated as a set of laws which mostly consist of principles and rules of behavior that bind states and therefore are usually adhered to a relationship of states to one another. In international law, you could see the customary rules also. And sometimes, I don't think the religious rules are there or not, but when you say customary rules, they are not against the nature. Most places, even a religious also, it is not against the nature. And because it is a uniform in the universe. At that instance, the function of the international law, namely as a system, international law is an autonomous legal system. It is an independent legal system, and where the parties are members of the different state, either they under the charter or under the treaty, they will make bilateral or or multilateral treaties, and they will see that a peace, harmony, cooperation, security will be prevail on the planet Earth, and there would not be any third world war, because war always brings disaster to the state. Even the state won the war, even the state lose the war, doesn't matter. So there is a autonomous legal system independent from the international politics. But only thing is they never enter into the politics. They enter into the relations. Of course, politics is a subset of relations. Except the politics, they don't enter, but they will see for the development in the different fields, from the agriculture to the technical, including the exchange programs also in the education. But in main function is to serve the needs of the international community, including the authentic state system. So whatever the what you do it for the international community should have to recognize your services. And in a particular, Casco Nieme concludes that function of the international law is to emphasize its task as a relatively autonomous formal techniques as well as the instrument for the increasing the special claims and agendas in relation to political struggles. And here they try to avoid the political and the struggle or enter into the politics, but in one way, in another way, it will touch us it. Definitely, it come into the picture, at least some stinge, some smell. At that instance, try to avoid the international politics and keep concentrated on the international relations in different fields, from education or agriculture, technical, or any other projects are concerned, including the investment. International law institutions have the excuse me, have the purpose and function for maintaining the realization of the ideas of a balance of interest, the ideas of the harmony of interest. A harmony would be there from one country to another country to make the country development. No country will develop without the cooperation of the another country. The presence of an agreement that is under an agreement between the countries with a different interest. Of course, the interest will be differ because they want to see that the aim should be fulfilled over there. What is the aim they do have it? It depends upon their foreign policy. It will be rest. How the foreign policy will be there, it will be rest on it. And hence, we say in that respect, yes, agreement is under an agreement between the countries with a different interest, they will make it out. So that is the important factor when you are making the international relations through international laws. The solution of this problem is how each country must comply, follow, and apply the international norms. And what are the provisions are say, what are the rules and regulations will be say to maintain, the promote and protect the human rights. It is envisaged there in the international treaties or charters. And the state who are the party to it, a signatory as well as ratified in their municipal laws, that we can say the international instruments are domesticated in the Tanzania. In the main, in many international instruments. So must comply with the international law. They should have to follow the what are the international law says over there, comply it, and promote order in the world. And they have to see a order would be maintained over there and the world. Why? And the achievement of the humanity fundamental goals. Why we are doing all those things? Our goal is to have a harmony, and the humanity would be protected, and human rights would be protected, and a man would live with the healthy conditions and without the malnutrition, with a good education, they will survive over there, and a peace will prevail over there, a good health would be there, and security of a person would be there, and that is the reason that we want the international instruments and international human rights law. And achievement of the humanity of the fundamental goals to promote what? Peace, prosperity, human rights, and environmental protection. It goes human rights, everything like a good health, a good education, a good treatment, and a good environment. All these things will come under it, and where it should be protected, because it comes inherent because of the, if you're born as a human being, automatically human rights are with you. So, however, over the centuries, there have been voices that have attacked the international law to promote the domination of hegemony of one country. So some of the countries, those who are very much powerful, they try to dominate on the other countries who are underdeveloped. But one should not do in that way. And the world should be a one family. A world should be a one family. At that instance, we will treat any person, our family, with the humanity, with the kindness, with the love, and then only prosperity would be there, peace would be there, and the human rights protection would be there on the planet Earth. That is the motto of international human rights law, which is supported by the different charters. Among them, UNDP is the one which is the mother of law for this international human rights. In addition to that, there are many charters are there, or the charters or the UN has given the special permission for the agencies to take care of the human rights violation should not be there. And hence, for controlling it, for taking an action against them, and there are the three regional centers are made. One is in the American, another in the Europe. For the African, we do have the African People's Rights Court in Arusha, and we are very proud that Tanzania having a court of the in the African continent, and to deal such a case, to protect and promote the human rights protection, and we will be proud of it for that regard, the Tanzania. So now this is regarding the politics and relations and how it will have the impact on the development of the country, or how it will have the impact on the human rights violation. So these are the things that we studied, and in tomorrow class we will see this one, and I will send this. Yes, I will send this piece of article to you in the email today, and you read it, see some of the points, so that it will be easy for me to go through it and get some answer from you. So that is my intention. Excuse me. So today, yes, how many participants are there? Only two, because one is missed. Masanja is missed. So what is this title? Can anybody unmute and read? Can anybody will unmute and read the title of article?
Human rights in the context of international relations.
Yes, written by Basti K. Fortman. It is published in the July 30th, 2011, and the human rights, and the journal is, of course, it will be there, international relations. On the website, it is there, and you can download also, or I can send you the article. And this is around about how many pages? It is international relations. It is published. 5 pages are there. So we'll deal in the next class. When do we have the next class? Monday. Yes, we will deal on Monday. Why? Today is Friday. Is it not? And again, we do have the Monday and Tuesday only, the international human rights law. Okay, we'll see in that Monday. By that time, have a good day. I would like to stop it. And asante sana, nashukuru sana, Mungu akubariki na kukulinda. Bye. End of the
Wabariki